Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers, with your hosts, Ben Siders and Kirk Damon.
Today's episode is brought to you by the Frestovian Order of the Asiago Ranch Chicken Club. Some adventures attack the darkness. We attack the deep freeze.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers, with your host, Ben Siders, that's me, and the other guy is Kirk Damon.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders, and you can find Kirk at KirkDMN. You can follow this podcast on Twitter at LGGPod and find all this information on our website, www.lggpodcast.com. We said in our prior episode, Kirk, that release dates may get spotty here
Yes,
due
exactly.
to general busyness, and that has come to pass.
Definitely. I think this one's releasing late. I think the next one's got a decent chance of being late.
I had in our notes for the prior podcast, I had written down, it's going to get worse before it gets better. And I think that still remains
It's still
true.
going to get worse.
We're both going to D.C. in October, so if any of you meet us there or have met us there and you're listening to this after the fact, hi, welcome. But yeah, we'll be in D.C. for a convention. And just general end of the year insanity. So
Yep.
We may not get back into record until November at this rate for our next episode.
Yeah, we'll definitely see how it goes. That's what it is. Yeah, for those of us who we're going to be at the AIPLA's annual meeting. So if any of you guys are interested in do that, American Intellectual Property Law Association, if any of you guys happen to be around, DC around that time, feel free to come see us and or give us a call, and we can try to meet up with you.
So today's episode is what I'm calling the grab bag episode. It's just a mishmash of barely related things that are interesting that Kirk and I want to talk about.
So not only are we, on a spotty schedule now, we're on a spotty, episode structure.
Spotty theme at this point.
Theme. But I think the real point behind this is we want to follow up on some prior episodes we've done. Some things have changed. And there's been some sort of developments in the law we want to talk about. And I think we finally realized we have enough of these to do one episode. So we figured it made sense to do it and get to it.
I think we've got basically 6 to cover. So each one's going to get about 10 minutes of short treatment. Some will get more than others. This first one's probably going to get the most. Others may only get a couple of minutes. But we'll start going through them. So the first one is, I have an announcement. We are wizards. We are Jedi. We can see the future.
We can see the future.
So we did an episode in November of last year talking about why the Electronic Arts college football game was no longer being made. So we're going to play a clip from that episode for you in just a second. It's 70 seconds long. But to provide the context, Kirk and I had discussed that the courts had, a year or two prior, actually quite a ways prior, ruled that Electronic Arts use of college athlete likenesses in the video game was not a fair use. And that EA had to get permission and, pay for it.
Yep.
The NCAA had stepped in and said, and EA said, okay, we'll do that.
Yeah.
But the NCAA stepped in and said, if the athletes accept these payments, they are receiving compensation related to their performance, which violates the NCAA's amateurism principle.
Yep.
And the athletes would then be ineligible to compete under the NCAA's rules. So the issue was not that the law doesn't allow players to receive compensation. Quite to the contrary, it practically requires it. The issue is that this private organization, the NCAA, has forbidden it. So here's the clip, and again, this is us talking in November of last year. There's a difference between being a professional athlete and an amateur athlete. But that, in this case, the instance doesn't really derive from legal requirements specifically. It's because you've got this private organization inserted into the amateur side, but its analog in the professional side doesn't impose this limitation.
Yeah. And again, part of the reason we look at that is because what they're doing is they're imposing a moral or policy limitation, which really, the law is not designed to regulate. It will do it when it's told this is what the outcome is supposed to be.
Congress could come out and say, we are going to forbid any public university that receives federal funding from participating in the NCAA or any of its activities.
Note that receives federal funding.
Yes.
We need a Commerce Clause.
Yeah. So USC, actually, all the private schools will still be in there. They still do. That's going to be their jurisdictional hook. We forbid you from participating until and unless X. And X will be whatever compensation arrangements they want to have for the student athletes. Congress could step in and fix this. And really, a state could too. I mean, these schools get funding from the state. So all it would take is Texas to step up and say, nope, we're not doing it anymore. But it wouldn't be Texas. It'd have to be Alabama because that's what everybody cares about now.
Well, I think any one of them could do it.
Yeah. Okay, so it wasn't Texas or Alabama. It was California.
I was the one right. I got the other states. Of course, I had 48 of them, and you only had 2.
Yeah, I should have gotten longer odds on that. What's the payout? So 2 questions that are interesting about this. So 1, the question that nerds care about: does this mean NCAA football is back? Well, and then 2, why California?
I think the first thing we should potentially do is just summarize a little bit of what California said.
Yeah. They didn't quite do what I thought they were going to do. They basically just passed a law. It's not connected to funding at all. They just passed a law that says nobody will be ineligible for competition in any sports competition or athletic competition, not by the school, not by the state, not by the NCAA or any other collegiate organization. No athlete in California can be rendered ineligible by reason of having accepted compensation for the use of their likeness.
Yep. Yeah, so the real key about this is in some sense it targeted this exact question, that we're looking at, the idea of likeness as use. But I think, the question we had in the case for all sports geeks is, does this mean we're going to see electronic arts NCAA football coming back?
And I think it's possible because this California law does not say that the schools have to pay the players. We don't have that going on. It's basically just saying if you have a player at USC and someone at the local car dealership wants to put him in a commercial and pay him $5,000 for it, they can, and the player cannot be held ineligible to compete because of that arrangement.
Yep.
And so I think, practically speaking, nationally, this might affect a half dozen players. I mean, there aren't that many college athletes that are famous enough on a national level to make this worth anybody's while.
Yep.
I would think locally, there's probably 2, 3, maybe a half dozen kids at each school who might be able to get on and do a local commercial for your local burrito joint or
something along those lines,
or whatever. You people from Iowa, Poncheros, line them up. But I mean, as far as the EA football goes, I think this is a domino that has to fall for that to come back. Yep. But there's a ways to go yet, right? Because this is just California; it's just students in California. So now we see other states are rushing to get legislation put together, so they're not at a competitive disadvantage to California. And the NCAA, their hand has now been forced; they're going to have to do something. And I think 50-50 odds whether they come up with some sort of regulatory or rules compromise that allows this to go forward versus they sue California on some ground and say that the rule is unenforceable.
I think the key thing you got to keep in mind here is, this is not the NCAA saying this. This is California saying this. And the NCAA can still say, well, you're still ineligible to participate under NCAA rules with any of our things, and basically just kick all the California schools out of the NCAA.
Yeah, I haven't quite thought through how this will interact because the NCAA is not the government. It's just this organization, right? So they've got a rule that says to compete in our competitions, you can't do this. And California's saying, well, in California, it's illegal to say you can't do that. So what does that mean? Does that mean that the NCAA rules just don't apply to games played within the borders of California? What happens if USC is playing Notre Dame at Notre Dame? Does that matter? I don't know. I don't know how this is going to play out.
Yeah, I think that's the biggest thing. And that's the biggest thing I think we had sort of with the question from it is, while it's an interesting domino to fall, the exact implications of what the next domino is going to be.
It's got to be the NCAA.
Yeah, is a very interesting question.
I know that they're doing working groups, I think, now to figure out how they're going to respond to this and what they're going to do. Yeah. I don't think it's that big of a deal as far as how it's going to impact collegiate athletics. But for EA football, there's still a logistical problem. Let's just assume that the NCAA comes up with a rule that says, okay, fine. Basically, we'll say what California said, that merely monetizing your likeness rights, that by itself is not enough to render you ineligible. You still got the problem of, this is not like the NFL where you just go to the players union, which already has all these rights licensed to it, and say, okay, we'll take a license. How do you go get all the permission from all these kids to do this? Because EA was before relying on fair use. They don't need permission from anybody. They just say we're allowed to do it. Well, that's not fair use.
Now they have to have permission. The court said that they have to have permission, and they agreed effectively to say we will get permission, but logistically they don't have permission yet.
Yeah, so then does the NCAA, do they act as that body? Do they say, okay, so for purposes of mass licensing, all of you need to assign your likeness rights to us as part of the conditions for play, at least to the extent of, national licensing for this kind of thing. You can retain your likeness for any other use. There's a way to sort of slice and dice that. Yeah. And I can't imagine a situation where the NCAA doesn't continue to insert itself in the middle of this process.
Yeah, they've got to, obviously.
And then maybe make a little coin on the side.
And I got to also wonder, it's the, exactly how it's going to be. They can't be ineligible to do it. is the NCAA going to respond back to something that says, well, you have to license your likeness rights to us to play an NCAA
and then they'll distribute the royalties.
And then they distribute the royalties not to the students, but to some sort of general, organization. I can see that kind of thing coming, some kind of general scholarship fund.
I think they probably need to set up a separate organization to do that. Managing royalties is well outside the NCAA's
well, yes.
expertise. I don't know. I mean, maybe they do that already, but I don't. They're basically turning into like the copyright royalty board, at this point. But for amateur athletics, I kind of feel like they want to outsource that to a specialist organization that knows how to handle it, can get the model, because the rules this is all state law. These rules all vary state to state.
And I think that's the biggest thing we're going to see potentially as a bump in this is that every state is potentially going to come up with its own law that may or may not mirror California in substantial respects, in all respects, in no respects. And that's, I think, where we're also going to then bump into it is the NCAA kind of needs to jump on this early to say, hey, we're going to try to implement this nationally. Therefore, states, you don't need to pass these kind of laws
we're just voluntarily
doing it, and now we don't have to deal with a patchwork law as to whatever. So again, when we look at it and sort of say, hey, this is the first domino falling, I think the answer is yes, it probably is the first domino falling.
I think there's another lawsuit that has to happen before this is all done. Like whatever the NCAA comes up with, somebody is going to sue them over it, whether it's the athletes or the schools or a state. Somebody's going to, there's one more dispute to be resolved, which is going to be whether the NCAA's solution to this is acceptable.
I think there will also be a potential challenge of the NCAA actually challenging California by just simply doing something. Again, whether it's setting up an organization or even saying California schools cannot play because of this, which will result in a second lawsuit between NCAA and the state of California, which, quite frankly, I'm not sure would be a particularly difficult legal issue to resolve, depending on exactly what it is. But it may just be a necessary step to have a court step in and say, you can't do this to the NCAA. So in some sense, the NCAA is saving face of saying, hey, we said you couldn't do this. We don't like people doing this, but the court now says we have to. So now we're going to.
I feel like the NCAA may be at maximum political fragility at this point with all the investigations going on with basketball, with some of the negative things that have happened in collegiate sports. I don't have a strong opinion on the NCAA one way or the other. I truly do not. But my perception, I listen to a lot of sports podcasts, and it is not a beloved organization by fans. Schools are very careful because it's basically a consortium of schools, so it is them. Players try not to badmouth it, but the general attitude towards the NCAA is not generally positive, and I think they're probably aware of that and will be careful with how they play their hand.
I think you generally have an issue of just we talked about this in the prior episode too as well, that so much of amateur sports is just not necessarily making sense anymore. It makes sense in a lot of areas, but particularly when you start talking about basketball, football, these
football's the main one because you have to play in college. I mean, the college system is the farm league for the NFL, whereas in basketball, you can go straight through to, the NBA and skip college, and baseball, if you're playing baseball in college, you're not going pro already, That's kind of how it is.
Particularly with the sports where you look at that they have, wide television coverage, that there's, sort of wide following of the collegiate level sports, not just of alumni and stuff like that, but of every school. We've got this problem, this being heavily monetized, sort of to the disadvantage of the workers. And I think, which is being the student athletes participating in this, and that being just an issue of, hey, there's a problem here. We recognize the fact that there's a potential problem here. What are we going to do about it? And I think that's why the NCAA a little bit is walking on fragile ground right now. You talk about, NCAA, fencing. I don't think you have any kind of these kind of issues because in many respects it's they're not making the kind of money. They're not going to get the interest in their likeness rights that these other things are. So we can almost look at this and say it's a fault of the consumer and the fact that we've become so entitled to watching collegiate sports on our TVs that has created this problem. We're only watching certain collegiate sports. At the same time, we have and we can't go back from that. It's not like people are going to suddenly stop watching the Final Four just because it's not necessarily good for everybody.
Yeah, the other dominoes to fall here are that the colleges and the conferences also withdrew their licenses to EA for the use of the team names and logos and things like that. Now, that was in response to all the uncertainty around these lawsuits. So presumably, if this all gets worked out, I can't imagine the colleges saying, well, we don't want that money. I mean,
I believe the schools are going to license them and they're going to take the money as to whatever. For a lot of schools, quite frankly, it's probably a good thing.
Unless this gets worked out way more quickly than I think is likely. I think we're probably at least a couple of years off before it's sufficiently sorted out that EA can really get back to putting anything out.
Even if they sorted it out this year, it'd be the next season before they could really do a game anyway. So.
So the second question, why California? I mentioned Texas for obvious reasons. Football is king in Texas.
Yeah, Alabama.
But it came out of California of all places. And while California has a lot of college football talent, none of the programs out there are especially good at football right now. Cal is bad. UCLA is bad. Stanford's bad. USC is not even that good. Like, they're all kind of not good. The Pac-12 conference out there is kind of not good and hasn't been for a couple years. Why does California care so much? And I've got two theories on this. One is that the company that makes NCAA football and therefore makes revenue off it and pays state income tax off of it is situated in Santa Monica, California.
Yeah.
So if I'm California, I kind of want them to make and sell this product and to pay taxes on the revenue they make off of it. The other reason, someone actually mentioned this to me this morning, the California law expressly allows the use of talent agents by these athletes to manage their likeness rights, which is a good idea. It reduces the chances of them being taken advantage of, at least in theory. Kirk, if I were to ask you which state has the largest concentration of talent agencies, where would you guess that is?
I would probably guess the traditional home of where the movie industry is, which would probably be California.
California, right? So yeah, I don't think, I mean, this is a little bit of a cynical view, but I don't think it's a coincidence that a state that largely doesn't care that much about sports like this has nevertheless passed a law that happens to benefit two significant industries that are located in that state. So good on you, California. You're going to force everybody's hand, and those of us who love playing this game are all grateful, but there's a cynical view to this too, which is it's a shallow cash grab.
And again, I think it's not like they're the only ones who are going to benefit. I think that potentially a lot of states, a lot of schools are going to benefit.
Well, and the students should benefit too, right?
Potentially as well.
This may be a nice middle ground between the schools flat out paying them and allowing the more well-known kids to profit.
Yep.
So so that's it for that topic. We have another athlete issue though. The player tattoo episode we looked at. More and more of these lawsuits are getting filed. Some of them are seeking millions of dollars in damages. If you didn't see the prior episode, we can run through the issues real quick. And we don't have much to say about this other than more and more of these are being filed, so it's going to get dealt with. But, tattoos are drawings, right? They're visual works of art that the tattoo artist, happens to use the human body as the canvas. But other than that, it's pretty much the same as any other drawing. So when you go pay a tattoo artist to put a tattoo on you, you're not buying the artwork. You're buying the service of getting the tattoo. No different than if you walked in and gave the guy $100 and said, here, draw me a picture of this, and you took the paper with you. You own the sheet of paper just like you own your own arm or wherever you got the tattoo, but that doesn't give you necessarily any rights to the artwork itself.
Yep.
You don't have the right to go make distributions of it and things like that. Now, tattoos are odd because by the nature of it, it's on your body and you can't get rid of it. So if you walk outside, you are publicly displaying the tattoo. That is a right that technically only the copyright holder has. So there has to be like an implied license. The tattoo owner obviously knows that you're going to go outside and people are going to see it. So they've implicitly consented to that. Likewise, you're going to be photographed in your Facebook photos and things like that. They know some of these things are just going to happen by the nature of a tattoo. But the situation changes a little bit when you have famous athletes with well-known tattoos like Mike Tyson's face tattoo or LeBron James has some famous tattoos. And those tattoos are reproduced faithfully in a digital recreation of the athlete in the EA NBA games.
Hey, wait a minute. It's an athlete issue, but it's also another video game issue.
And that's what these lawsuits are mostly over, is that these tattoos are being copied or reproduced, which is also an exclusive right that belongs to the copyright holder, and then publicly displayed in video games and things like that. So this, to my knowledge, hasn't been resolved yet. I actually think there's a decent argument for implied license as well. You're tattooing one of the most famous NBA players in history. Do you not realize he's in this video game and that they're going to reproduce the tattoo there?
Yeah, you've got some issues in conjunction with this and the fact that you're clearly altering somebody who altering the likeness of somebody who clearly has value in their likeness. And, they're paying you to do that. What I wonder about with this is that if it isn't something where what we're going to see is just essentially form language that arise, that when you walk into a tattoo parlor, the tattoo parlor is going to have to say, this is the license rights that I grant you. It's going to be some kind of default form language.
Well, that's what agents are doing now. Like you're seeing sports agents start to include with tattoo artists, when they get these, or include what their their athletes, when you get a tattoo, make sure you get these rights, and they're writing up stuff to include there.
Yeah, and so I think that's a lot of, quite frankly, where this is going to go. And you have to wonder how much of this is the reason these lawsuits are being filed is because we have a little bit of sort of precedent that says it can work, and we have a lot of people who have not done any contracting around it because there was no need to do contracting.
Again, the cynical view is that this is a cash grab by plaintiffs' lawyers who are taking these cases on contingency and looking to buy themselves something nice.
Well, you have a lot of it. It's the idea is these are cases where there wasn't necessarily a cause of action here 10 years ago because nobody thought about it.
Yeah.
There is now a cause of action here, and there's a lot of people that have gotten the tattoos in the intervening time where there is no contract. So we kind of look at it and say, 20 years from now, these cases will not exist because it will all be governed by contracts. There will just be default agreements as to what it is. 20 years prior, it didn't exist because of the fact that it was a non-issue. But for this window, these cases exist because there is no contract and there is an issue.
Or we'll get one of these to a decision, it'll get appealed, and you'll get the Ninth Circuit will say, no, it's a fair use, or it's an implied license or something like that, and then it will just all go away. But if I'm putting on my hat of what if I was the lawyer, I guess I'd be looking at like the players union of the league and saying part of my contract with my players is going to be, we make a lot of money off licensing these rights. So you need to, the player, promise to us, the league, that you will take care of this stuff. And if there's a problem, you indemnify us if you don't get your tattoos or other body art or things like that dealt with.
I think there's a future issue coming in this, which hasn't yet, which is also going to be when they have something tattooed, which the artist does not actually own the copyright in.
So that's the next question, right? Like
afield.
I wonder about that. Like, so if so a lot of people just go to the tattoo parlor and they've got a picture of what they want.
Yeah.
And the tattoo artist just copies it. Well, presumably that's somebody else's copyright, right?
No, maybe there's a lot of people I know who've gotten them have done their own artwork. They've purposely done their own artwork.
Or they see something they like and they go to the same artist and say, I want what that guy got. You know? But I wonder if in situations where someone will Google something and then print off a picture from Google and then say I want something like this, it's at least a derivative work, arguably. So if you've made an unlawful reproduction that's then being publicly displayed everywhere, the original author didn't impliedly consent to that. So I don't know how that would shake out. It's an edge case. It's a good law school exam question.
And the even further one, just even taking it as more of an edge case, is the people where what they actually have tattooed is a corporate trademark.
Yeah.
From another corporation, where you now not only have copyright issues, you have potential trademark issues, bumping into this type of thing.
How could you enjoin that? A court's not going to issue a ruling ordering somebody to have a tattoo removed.
Yeah. It's just not going to happen. But you've bumped into this. Well, but can it be reproduced? Can we talk about the fact the person has this? Because, not only is it potentially something where you have a copyright issue, but I may have a disparagement issue. I don't like the way this player plays, and yet they have my corporate logo
displayed on them. Or they're getting into trouble, off the field or something like that.
Yeah, those kind of things with it. I think this is an area where we're going to have a mess for a little while. And I think that's sort of the way we concluded it last time, is it's probably an area that's going to be a mess for a little while. What I think we're seeing right now is because it's a mess, we're seeing it go to the courts. The courts are doing what they're supposed to do, which is deal with the fact that these disputes exist right now. What we then expect to see come out of this is there will be some resolution, whether it comes from Congress, whether it comes from court holdings, whether it comes from private contract. I think it just depends on who gets hold of it first. That will resolve the issue in a way that sort of everybody knows what the outcome is. And that will sort of lead to the glut of cases going away as we all do whatever it is. So again, it may just be that a rider in every person's contract is you have to own if eventually you get a tattoo, you have to own the rights to your tattoo. Get the rights
so that we can use it the way we want to use it.
Yeah, something like that.
One other edge case, and a question I have not seen raised yet, is the Visual Artists' Rights Act, VERA, which is the U.S.'s, was it the Berne Convention we're complying with? So the short version is that the VERA rules say that the artist has certain rights in the original copy of the work, the original version. And one of those is the right of integrity, which means that it cannot be destroyed. Wait a minute. So the original is on LeBron James. Now, you have to reach certain threshold levels of notoriety before these rights kick in.
Yeah.
But in theory, if you're famous enough and your tattoos are famous enough, you could meet that threshold. Yeah. Does that now mean that the artist can no longer remove the tattoo without destroying the original?
Well, I believe the artist could if they owned the copyright in conjunction with it, but another artist potentially could not. Yeah, the athlete could not.
Yeah, so that's another one I think where the court would say, no, you can't, the VARA is not going to trump your right of autonomy over your own body.
Yeah, and that's what gets weird in this is because we assume sort of copyrighted works, like VARA and the idea of these destructions is it's a mural on the side of a building. That's kind of what we're assuming in conjunction with it.
That's not the case here.
But that's not the case here. We're talking about something which, inherently involves the human body as well.
Okay, so the next issue we've got, another sports issue. You may have recalled a couple months ago now, Kirk and I got on this podcast and talked about how the Blues had won the Stanley Cup. It never happened before, and shortly thereafter, the Toronto Raptors won the NBA championship. Toronto has since been, actually they got sued a long time ago, a couple years ago, but it has renewed vigor now.
Yeah.
Toronto was sued by Monster Energy drinks on grounds that the quote-unquote claw logo used by the Raptors is too similar to the Monster Energy drink claw logo.
Yep.
And we'll try and tweet these out. Hopefully we remember to, but we'll tweet them out so you guys can see them and compare. Setting aside the likelihood of confusion between the logos, Kirk, do you know anybody who doesn't understand the difference between professional basketball and beverages?
They don't. I mean, it's one of those things that I think could be pretty apparent as to the goods and services, but isn't Coca-Cola right now putting out custom cans, or is it Dr. Pepper, with logos on them for football teams? Wait, maybe this is the issue we're getting at, is we've got sort of this cross-sponsorship deal, and particularly the fact that these cross-sponsorship deals are becoming more and more common as the technology, and my understanding is it was actually a technological improvement that's now allowed these beverage companies to manufacture individual cans, so they can actually make small runs of cans.
Yeah, like Dr. Pepper does all the college football stuff, so all their cans have football things all over them in the fall.
Yeah, but I know they're going to do, I think it's logos or helmets or something along those lines in conjunction with them. Now we're starting to see, hey, wait a minute, does that mean the monster looks like it's between the Toronto Raptors logo? The other problem is it's the wrong way round. We've got the Monster Energy suing Toronto here, not Toronto suing Monster Energy. Now, presumably that may have just timing as to when these things came into play.
I think that's part of what this is that because this case I think was filed in 2016 or 2017. It's been kind of sitting there for a while, and it's gotten more interest lately because suddenly there's a demand for Raptors gear. So there's a lot more sales of potentially infringing products out there.
Yeah, and it's the thing I think is interesting about this is, and I really think the cross-licensing thing here is interesting. We can look at it and say there's really no likelihood of confusion between energy drinks and professional basketball teams.
That doesn't even pass the laugh test in my opinion.
But what we're seeing is the fact that there is sponsorship and cross-sponsorship growing more and more in disparate industries. And is this a harbinger of what is to come in conjunction with future trademark suits, where the goods and services distinction may not matter as much?
Yeah, you get into the situation where since everybody can use everybody else's trademarks in these things, do consumers really fully appreciate the distinctions among these various organizations?
Yeah.
Especially when you get into like a Pepsi or a Coke that owns a large number of brands under its umbrella, or even like TV channels, like it's no coincidence that all the Disney movies are being advertised on ESPN and ABC. It's all part of the same corporate family. So you wonder about those kind of things and whether the way that trademarks get used now is resulting in sort of de facto dilution and blurring in the marketplace for people like, oh, Dr. Pepper, that's the football soda, or Busch, that's the NFL soda. I don't even know what it is, the NFL or beer. I don't even know if it is anymore. I think it was at one point, but it's like I'm the official sponsor of this or that. So does that create problems?
Well, you kind of bump into the same thing in conjunction with a certain large football game that takes place in February that you can't use the name of because
the excellent bowl, the amazing bowl,
the large bowl,
the super game.
and those kind of it's the same issue. You're sort of seeing coming into these things is we want official sponsors to be able to say that's what they've connected to. We have these official sponsors. They're the ones who can put the logos on there, can do this. Obviously, because official sponsors, you're going to be paid license rights. I mean, that's part of the idea behind being an official sponsor. But I think that's what you're getting into now, is you're getting into this sort of question of these blurring of the lines of just media has become so pervasive, trademark use has become so pervasive, everybody's using them, they're all over the place. There's a much greater likelihood of people just simply being confused of what is official and what isn't official.
Yeah.
Something we've talked about even in this program before, and I think it's what you get into in copyright, is what's canon and what's not canon.
Yeah.
And you talk about the Star Wars universe or the DC comic universe or the Marvel comic universe, what's canon, what's not. Is kind of the same question we're not getting into trademarks, is what's sponsored and what's not.
Speaking of which, it's hockey season again, and the aforementioned Stanley Cup champion St. Louis Blues are playing, so we're all excited here. After the Blues won the Cup last summer, there was a merch rush. I was part of it.
I was part of it as well.
We were all part of it. People who don't know anything about hockey and have never cared, nevertheless, got caught up in the mania.
Own Blues gear, yeah.
A lot of people... and
my daughter was actually upset because they had a Blues Pride Day where they could all wear their Blues outfits to school, and she, of course, doesn't have a Blues shirt because we haven't gotten her one because she outgrows everything.
I've been following this Twitter feed called STL Cup Tracker, which there's a whole story about that I won't get into, but basically this lady here in St. Louis decided to track where the Stanley Cup is around town all summer, and then finally the Blues brought it to her so she could see it. But anyway, I thought it was leaving town. I think it leaves today or tomorrow, but I'm laying in bed last night. It's like 10 o'clock at night, and I see on my Twitter feed the Stanley Cup is at the Recplex South in St. Peters. And it took all of my willpower not to get up, throw on some clothes, and drive. That's like 10 minutes away from me. And I was thinking about it, and that was about when I saw someone say, no, it just left. It's heading out west. Nobody knows where it went. And I lost track of it. But I'll have to go see it in the Hall of Fame one of these days instead. Anyway,
yeah, my son saw it, my wife saw it, and I didn't, and my daughter didn't.
The Stanley Cup itself is interesting from a trademark perspective because it is not actually owned by the NHL.
Yep.
Lord Stanley, I don't know the story fully, but I believe that he gave it to a couple of trustees to hold, and they give it out to whoever wins the Professional Hockey Championship of the year. The Stanley Cup itself predates the NHL by quite a bit. I think it was the 1800s, maybe? It was when it was originally built. So it's very old, and but the NHL, I believe, owns a trademark registration for the likeness of the Stanley Cup, like the shape, which is iconic.
Yeah.
Sort of the trade dress in it. So there's a question there whether the NHL is the proper party at all here. But at any rate, I can tell you that once you slap Stanley Cup on something, it costs $25 more than it otherwise would. I don't know if that's the licensing fees or the market demand, probably a little bit of both. So we had a number of people around town who were doing Stanley Cup promotional things, and most of them got away with it because what's the NHL going to do to St. Louis after this?
Well, especially since they're probably making a large amount in licensing fees because of all the people who are doing this officially.
But relatedly, we had the whole Gloria phenomenon. Yep. So if you don't know what that is, 80s pop artist Laura Branigan performed the song Gloria, which I would hum a few bars, but we don't have the licenses, so I'm not going to. So go look it up. Gloria, St. Louis Blues, you'll find it. The minute you hear it, you'll remember it.
Yep.
It's one of those
and most of us,
songs.
I think, remember it even without it. I mean, it was a very distinctive song. It was almost an anthem of the 80s.
Yeah, but it was written, I think, in the 70s by somebody else, and they have even been Italian composers, I think. We may have talked about this before. At any rate, one of the things that a lot of people have wanted to do around St. Louis is to slap Gloria on everything.
Yeah.
This presents interesting questions because the song is called Gloria, but the song is copyrighted, Kirk. It's not trademarked. You don't trademark a song name.
And Gloria is just a woman's name. There are a lot of women named Gloria out there.
Yeah. I mean, there are other songs called Gloria. There are a number of church hymns called Gloria, right? So, the trademark issue set us, and then the bar in Philadelphia that started all of this is Jack's NYB in Philly, which, by the way, we were out there back in May. We should have gone. But Jack's has applied for trademark registrations, but they only applied after, I think. This all got very popular in St. Louis, so I don't even know if they're the correct applicant. I guess we'll find out.
Yeah, I think the issue you got in conjunction with this is there's a whole lot of confusion around this, and this is not the first time this has happened.
No, Ohio State tried to get a trademark on which was denied.
Well, but I mean, there's also been a lot of things where things have suddenly got attached to sports franchises or something. St. Louis as well, we can pick on another one. Let's pick on the Rally Squirrel.
Yeah. These things tend to happen organically. Yeah. But then people jump on it and try to lock up all the rights to it.
Yeah, and I think part of the problem you bump into with it is you bump into the idea that when you get these sort of third-party things that kind of pop in and something pops out like that, the league suddenly loses control of something. I can make T-shirts that just have the word Gloria on them that are in blue and yellow, and the question is, who do I own rights to? And it may not be the league.
I have one.
Yeah, it may not be the league, and it suddenly bumps into but people want Stanley Cup Blues gear.
Yep.
We can't have people making these kind of knockoffs, particularly that we can't stop.
Mm-hmm.
And I think that's the kind of thing that we really get into with these, is when you get these kind of sudden bursts like that, particularly in playoffs, particularly in stuff like that. And again, the Rally Squirrel is another great example.
Yeah.
I think you bump into questions of who owns the rights here. What do they own the rights to?
And the answer is nobody does until somebody does, right? So Rally Squirrel, well, whoever wants to sell it first, the minute you've got the intent to sell a product, it's completely legal to go register the trademark. There's nothing inherently wrong with that.
And the Rally Squirrel is a great one because how many people actually remember the Rally Squirrel? I mean, I mentioned that.
I didn't remember it until you mentioned it just now.
It's something that was huge in St. Louis for, I think, for one playoff run.
Yeah.
But it sort of then died out very, very quickly. You got to wonder, will we remember Gloria 2 years from now? Is this going to be something that dies off?
Yeah, it depends, right? Like, I know that they're still playing it. I watched the banner hanging, and they played Gloria after that. Yeah. And like Layla, that was involved with the team, she's still around doing stuff with them. Yeah. So I think they've figured out they've got a lot of goodwill in the community. Well, it's
only like 4 months away, past. So
yeah, it's in the recent past where everybody's still kind of elated from the win, and there's just so many good stories that went with that team.
Yeah.
That it's appealing, and you can understand why people want to get in on it. But one question that I've heard asked a lot is people often say, gosh, I wonder how much Laura Branigan has made off of all of this. And you and I have talked about this, and we think the answer is probably not that much.
Yeah.
And the reason is because basically, in music, there's no public performance right for the performer in a sound recording. And Laura's not the songwriter. These other two guys are. So they've made probably
and
a
even
ton.
in songwriting, there's fixed royalties for what it is for public performance.
But for a public performance in a non-digital setting, so all the plays at the arena, at rally events, at the parade, none of those, she doesn't get anything for any of that. Or radio plays even.
And a lot of these, when they're covered, the arena buys essentially a license to play whatever it wants, and it pays a fixed fee to, whatever
and then ASCAP or BMI allocates that out. Or
so the fact that they're playing, one song 99% of the time they're playing music doesn't alter necessarily how the royalties are distributed. I don't know how they do it internally if they pay any attention to that. But it's one of those things where I think what you really bump into is, yes, there's some money changing hands because of this, but it's primarily the songwriters. It's not going to be the artist. And it's not necessarily going to be related to the amount that song has been played in a particular location.
Speaking of music, the three major music labels sued Charter in March of 2019, alleging various things, but one of the more interesting ones is that Charter's high-speed internet packages encourage music piracy. Now, I'm a Charter customer, so full disclosure, but in my notes here, I have eye roll emoji written down.
I think it's accurate, somewhat statement here.
The amount of bandwidth you need to download music is not that much. People did this back in the 90s on 56 baud modems, 28.8 modems. You don't need that much. I just can't imagine. They have legitimate arguments, I think, about not, people who are perennial abusers under the DMCA. They keep sending takedowns, and the same people keep doing it, and then the ISPs don't always respond promptly. I think it's hard to keep track of that stuff, but maybe I'm wrong.
I think one of the things you get into in conjunction with this is and you got to wonder how much of this is them just trying to find some target for piracy. It's you can go on the internet and you can find the numbers. I mean, piracy is a huge problem. Everybody acknowledges it's a huge problem, but nobody really knows quite how to deal with it because it's only a huge problem because it's death by 1,000 microcuts.
Yeah.
And it's very, very hard to stop 1,000 microcuts. You may be able to stop 50 of them or 100 of them or, half of them, but that's not enough.
I think they've done about the best they can do. I mean, I think the answer is probably not legal here. It's a commercial answer, which they have. We have the iTunes store.
No, we don't have the iTunes store anymore.
Yeah, we're not going to for long. I mean, streaming services, I think the problem's going to go away. Sales of records and albums are down because nobody wants physical media anymore, except Kirk.
Actually, records are going up. Apparently, the sales of physical vinyl records are up.
Oh, did you hear that?
The sales of cassettes apparently are up.
Well, if you listen to 80s music, that's how that music was meant to be heard.
There was this desire for, the vinyl being the correct way to listen to music. Now there's this desire the cassette is the correct way to listen to music.
I cannot understand that. The cassette was such an ill-conceived technology.
Except that it was portable. That was the thing with the cassette.
Durable, right?
Yeah, it was portable and durable, and that's why the cassette was so good. I mean, even when CDs first came out, cassettes still had the advantage that they were portable and durable because CDs would melt in your car, and stuff like that. So I can get why cassettes have a certain popularity, but the question I think you really bump into is how much of this is just nostalgia, for the things. Though I do have to admit, and it's just for me personally, I bought music off of iTunes, individual songs, albums, stuff like that for years. I've gone back to buying physical albums. And a lot of the reason that I'm doing it is, one, iTunes is a pain, particularly now since it doesn't exist. But the other thing that I really bumped into in conjunction with it is I don't want to deal with having to have them only on the iPod. I want to have them other locations. So it's one of those where it's like, I have my old 90s era, portable stereo, boombox. I'm going to be 80s for a second there. Which is great to play CDs on. My kids love to use it. It just sits in our living room. It still works. Our kids put CDs in it. I can't hook my iPod up to it. It's too old. And so it's one of those things where, I think you've really got some ideas of the people are kind of looking at these things and going, there actually is some value of physical media.
Yeah, so I got a new receiver for our living room, which is Bluetooth enabled. So I can just connect my phone to it and play music through the living room speakers through my phone.
Yep.
But, Bluetooth's not perfect. I'll wander too far away and it cuts out, and little things like that happen. So these little minor annoyances show up. Speaking of ridiculous claims of IP piracy.
Well, not necessarily claims. I mean, it's claims, but...
In 2011, I contributed a chapter to a book published by the American Bar Association on video game development, sort of an IP guide for non-legal people to understand the law for video game developers. And I'm going to read to you, I know you guys don't like that, but I'm going to read to you a couple sentences I wrote. And it was a note of caution to video game developers. And I'm going to redact a bit for brevity, but here's what I wrote. Product placement is everywhere. Good custodians of branded properties aggressively police their use to ensure that their brands and products are not threatened through haphazard public use or unwanted associations with unpopular public figures. This may seem an esoteric concern, but product placement issues can sneak up upon the unwitting designer. For example, virtually every game involving car racing or sports requires the use of trademarked property. Even flight simulators and war games can implicate this concern. If you don't want a cease and desist letter from the multi-billion-dollar banking, chemical, automotive, and electronics holding company known as Mitsubishi Group, you might want to talk to your lawyer before you include that Mitsubishi Zero in your World War II game, period, end quote. Now, Kirk, I'm being a little cheeky here.
You're a wizard again.
I'm a wizard again. Mitsubishi's obviously not going to go sue anybody over the use of the Zero. Nobody, how dare you?
It's unlikely. Yes.
Unlikely. However, in 2017, the makers of Humvee sued Activision Blizzard for depicting the Humvee in the Call of Duty games without Humvee's permission. So they argue, of course, trademark infringement and more specifically trade dress infringement. It's not a bad claim.
The Humvee is a pretty recognizable vehicle.
I mean, I'm not a car guy, but I know a Humvee when I see it.
Now, it's a Humvee, not a Hummer, if I remember correctly as well.
Yeah. So I'm not saying that they got the idea for this lawsuit from me, but I'm also not saying that.
But I think the interesting thing with it, and a lot of what we're doing in conjunction with this is, it's a potpourri episode, yes, we're following up on all these things, but we're pointing out the fact that these issues are continuing to crop up.
This is something I would have said was one of my stupid law school ideas. Like, this would be a fun law school. Fine, it'll never happen, but it's such an absurd fact pattern.
Yeah.
How would you deal with it? Well, there it is.
Yeah, and the answer is no. It's actually a case, and I think that's the great thing about this is to sort of say, hey, we've talked about these fact patterns. We've talked about the fact that there's this kind of stuff out there. These things are continuing to happen. That's really the take-all from this grab bag is these things are continuing to happen. These cases are not going away. Some of them are becoming more popular. Some of them are becoming less popular. Some of them have drug on for a long time, and I think that's our...
Speaking of which...
next anecdote...
Kirk, who owns the rights to Ms. Pac-Man? Nobody knows. So Ms. Pac-Man was created in 1982 by 3 MIT dropouts who worked for a company called General Computer Corporation, which, by the way, is a terrible name. Don't ever call your company General Computer Corporation. The original Pac-Man was created by a Japanese company, Namco, and distributed in the U.S. by Midway. But Midway had become impatient for a sequel to Pac-Man. They had sold what they could sell, and Namco was kind of dragging its feet on getting the next Pac-Man out to them. They had a Super Pac-Man in the works, General Computer Corporation was a mod kit company. They'd already been sued by Atari for making mod kits for Missile Command, and they had an injunction that ordered them to stop doing that unless they get permission. Well, General Computer Corp had in the works something called Crazy Auto, which was a mod kit for Pac-Man, and rather than just dump it since they couldn't use it anymore, they went to Midway and said, "Do you guys want it?" And Midway said, "Sure."
I think an important thing to keep in mind at this point in time, mod kit, also when we're talking about it, we're almost talking hardware.
Hardware, we are talking hardware.
At this stage, this is not something where you're just talking, hey, you created extra levels and released them on a CD. This is serious engineering. These were hardware games.
Yeah, new P-ROMs. Like you have to pop out the circuit board thing and pop in a new one. So Midway bought the rights to Crazy Auto and then worked with Namco to get it ready for release. It was rebranded to Ms. Pac-Man, I think, less than 70 hours before going to production. And the Ms. Pac-Man idea was actually Namco's idea. And I don't know if this is retconning or not, but there's an interesting side social reason. Pac-Man was interesting because the majority of the players at the time were believed to be female.
Of Pac-Man.
Of Pac-Man, at a time when games were very much a male-dominated industry, more so than now. It's also, I think, one of the first video games to have a female protagonist. It may be the first video game to have
Female being debatable for a circle with basically a giant mouth. But
well, originally she had hair, and the Japanese director said, take it off, So there was some debate whether to call it Mrs. Pac-Man or Miss Pac-Man, and they liked Miss Pac-Man better because it rolls off the tongue a little better. But someone at Namco said, wait a minute, we've got an intermission scene that shows a stork being delivered. Do we want to raise questions about the
baby Pac-Man?
But delivering the baby Pac-Man, this may raise questions we're not really interested in answering about the relationship between Pac-Man and Ms. Pac-Man. This is absurd, right?
In many respects, yes, and under modern counts, sort of the concern here is kind of absurd. So at the same time, it's kind of impressive that they were actually paying attention to it.
But they even thought about this, right? So they went with Ms. Pac-Man. So I'm going to say that Ms. Pac-Man is actually a low-key contemporary feminist critique.
Well, I think the thing you get into with this, and again, I think, we're making some jokes about this as to what it is, but, part of the argument with this is there really any difference between Ms. Pac-Man and Pac-Man?
Mechanically, no.
Mechanically, no. And as I sort of joke about it, it's also, yes, Ms. Pac-Man has a bow.
Also a better game, I would argue.
Yeah, well, there's some argument that they figured out more what they're doing and knew what they were doing in conjunction with the hardware. But I think the thing that's interesting sort of from the background of it is how much is there really a difference in this? And yet there's clearly worry in conjunction with the companies having to do with gender issues.
We're still fighting about this.
And we're still fighting about it. And that's the other thing with it.
Yeah, that's the thing. Due to the unusual way it was developed, where it came from a third party, the ownership of the IP rights and the resulting royalties it still remains unresolved all this time later. There was an agreement in 1983, a second agreement in 2008. GCC is still around. I'm guessing all they do is collect royalties off Ms. Pac-Man. But it's not clear. I don't have the details since I couldn't find the contracts if they're even available to the public. But it's not clear who owns what rights to what part of what.
Yeah.
None of this really mattered, though, until a company called At Games, which makes legacy throwback mini consoles and arcade cabinets. They came to Namco and said, we want to do a Ms. Pac-Man console, and Namco said no. They did other things together, but not this.
Yep.
According to Namco, At Games went ahead and made one anyway. And it's not clear to me if it's actually been commercially available or not, but they claimed they made one, and there was a lawsuit filed over it.
And the only thing you have in mind, and it's just when we breezed over with this, it's not that there weren't disputes on this and sort of ongoing disputes. Most of them had settled. I think that's the sort of key thing to keep in mind. There were some disputes over this that had settled, and we're talking settled back in the 80s. In conjunction with this, the companies were happy, but because we're seeing this wave of nostalgia for one of these old games, which are still under copyright, copyright's 100 years, sort of
They'll be
under
copyright after all of you listening to this are dead, so.
Yeah. So it's one of those things where what we're bumping into in conjunction with this is now this wave of nostalgia. The copyright is still held, but there's still these underlying questions of who actually owns it.
Yeah, and it's weird because this was filed, I think, in August of this year. Then afterwards, At Games went to the General Computer Corporation and bought the rights to the royalty stream. So whatever rights GCC still has, now At Games owns them.
Yeah.
So I don't know where this is going. It's a really odd situation, and I think the reason it's still not clear who owns what is probably because the paper record's not that clear.
Yeah.
This is a version of the Dungeons and Dragons episode we did 2 episodes ago involving Arneson and Gygax's disputes over royalties. These documents were written in the 80s under a certain set of facts. Well, the world has changed since then, and now it's not clear. Do those agreements still cover what's being done now?
The other thing with it, I think the key things we got here, we got 2 pieces of it. One of which is we've had a dramatic change in the world. We were talking, stuff going from computer games being hardware consoles that you played in video game locations or maybe in the local sandwich shop if you happen to be lucky enough for them to have one, to video games being pervasive, potentially now the largest form of entertainment in existence. That's a dramatic change. The same piece behind it is not only has that sort of technology changed, but we've had changes in the law associated with this, what's changed in conjunction with the law. We also have the issues that I don't think anybody necessarily realized that Pac-Man was going to become the icon of the 80s, when they originally created this game.
Not to mention that it would then be revived due to a popular nostalgia for retro gaming. I mean, in 1996, did anybody really care about Pac-Man? I mean, like there's like a PlayStation 2 version and some some things like that.
Yeah, we were all much more excited with hey, we've got better graphics. We got all this great stuff. Hey, look at all this new Nintendo stuff coming out. It's all new. It's not stuff we'd seen before, and yet now there's this huge desire for retro gaming. I mean, let's talk about World of Warcraft Classic. I mean,
yeah, I am a subscriber. I'm level 34. It's amazing.
But we're seeing this kind of idea of like retro gaming.
The NES Classic is back.
Yeah, you could also wonder if part of it's just because of the fact that sort of modern games are so much more complex than any of these old ones are. There's a value to having a game that you can just sit down and play.
I think it's people our age who are like, well, I still remember how to beat Mario 3. I just can't play it.
Yeah, exactly.
Whereas I can't keep up with these high school kids that are playing Fortnite.
Yeah, and so much of the games now. There's a lot of Twitch games. There's a lot of things where it's and I joked about this, and I think I've said on this podcast, and I've talked about it with other people. It used to be that, when you walked into the arcade, all you needed was to look at the controls and watch the, 10-second intro on the screen to learn
everything
how
you needed to know
to
play the game. Yeah.
Now, then it went to you need the instruction manuals, which eventually got into instruction books. I mean, like literal books. Then you got into, okay, well, the book is no longer shipped with it, but it's sold separately, and you can get the book that explains how to play the game.
Or you need the third-party online database of all the stuff that's in it, like classic WoW.
Yeah, whereas now, all of a sudden, it's hey, there's enormous amounts of YouTube channels. There's hundreds of different YouTube channels dedicated to a single game, which are making millions of dollars, in explaining how to play the game, how the statistics work, trying to do the math behind it. In many respects, they're reverse engineering what the programmers are trying to hide, to explain how to play the game. You've got this sort of totally different world that we're into now. How much of it is people looking at it and saying, I want a game that all I have to do is start up and I can figure out how to play, and that's all I need to know. Like, I don't need to know anything else.
Speaking of unnecessary complexity, Kirk, what have you got in your hands over there?
So this is something I just found out about. I don't know exactly when it came out, but I thought this was great. It follows up with our D&D episode, which is that Wendy's, the hamburger joint, has presented Feast of Legends, which is a role-playing game. Feast of Legends is a full-out role-playing game. I don't know if you guys have seen this.
How many pages is that thing?
It's a 97-page full-color rulebook.
We'll tweet out a link to the...
So it's feastoflegends.com. But, I mean, this is a fully playable RPG. I mean, it's a bit bare bones in certain respects as to things
97 pages, how bare bones can it be?
Well, it goes through a lot of things that are, modifications and stuff like that. Your characters are not terribly complicated. I mean, you have, a strength, intelligence, charm, arcana, grace, defense, and hit points. Resistance, weaknesses, and advantages, disadvantages.
No hunger rating?
What you're carrying, how much gold you have, particular skills. And then what I think is great is these order skills.
Yes, let's go through the orders.
So the orders, when you select an order for what it is.
So just to clarify, this is like a player's handbook, like a Dungeons & Dragons player handbook.
There is a player's handbook, and the second piece of it is referred to, I believe, as the Game Master's Handbook.
Yeah, complete with
Game Master's Guide.
Like properly themed art, and the art is done straight. It's deadly serious art. It's not cartoony and goofy. If you were to tell me that, take the text out.
Yeah.
If you just showed me the art and said, look, it's D&D 6th edition, I would believe you.
The orders, and again, order being a play on the fact that you order food here, obviously. The order is all based upon what your order is for food.
Yeah.
So you can be, for example, the order of the chicken. You can also be the order of the beef. But underneath each of the orders, like, for example, the order of the chicken, the art of the chicken, adventurers who are trained in the art of the chicken are often seen as magical.
How about, so I would be the order of the spicy chicken.
You'd be the order of the spicy chicken sandwich, which needless to say is your fire mage.
Yes.
And that's exactly it. You are the order of the spicy chicken sandwich. I personally would love to be the order of the Asiago Ranch Chicken Club, which I think is kind of hilarious.
Get it?
Yeah. And so, stuff like that. They have, full gear guides in here. I mean, one of the things I think is great is in the gear, your armor can be things from a hamburger bun to bacon armor, which of course is heavy armor, which I think is kind of great.
I like that you have a fork as one of your weapons, also the great fork.
A great fork and a spork. The locations, there's a fully playable campaign in here where one of the places you have to go to is Frosty Canyon, which has 2 lakes, vanilla and chocolate.
Now our hero, what's the hero's name?
So the leader,
the lore.
you are actually in the town as to what it is. So you're in a specific location. The world is in the realm of Beef's Keep, in which Creeping Vale and the United Clown Nations have led their people into a collective darkness known as the Deep Freeze. While it feels like a cold and desolate place, you reside in the one nation that remains a true beacon of hope, Freshtovia, who is led by Queen Wendy. And I love the Queen Wendy, first of her name, breaker of fast food chains, defender of all things fresh, never frozen. The Clapback Queen has been the ruler of Freshtovia since 1969 and defends their realm from the treacherous evils of those who practice the dark art of frozen beef. And Queen Wendy has a full-color drawing in here.
I may need to change my Twitter description to that I fight those who practice the dark art of frozen beef.
But it's what I love about this, and sort of what I think of it is this is obviously a marketing piece. So no question, this is a marketing piece.
That's an elaborate marketing piece.
It's an incredibly elaborate marketing piece. It's actually a pretty well done, basic core game system. Now,
your character's attributes depend on what you, the player, have eaten that day. So if you had gas station food, you lose 2 intelligence for the campaign.
If that's what you're currently eating while playing the game. But yeah, so there's just a bunch of sort of stuff in here. But following up from our D&D, episodes as to what it is, we have this, which is a role-playing game, which is clearly a fantasy universe. This thing has some tongue-in-cheek components to it, but we see, what does this mean for role-playing games? Is this a legitimate role-playing game? Could I infringe a copyright in this? How would I, without necessarily getting in all over Wendy's intellectual property and, sandwich names and stuff like that? But, some very intriguing stuff with, where does this
I
kind
want
of
some
thing
Wendy's
get to?
now.
Yeah. Well, and the last thing I had with it is, and I jokingly mentioned this to you on the way over here. Can you play this in prison?
Yeah.
Now, admittedly, you obviously cannot get Wendy's food, I'm pretty sure, at vast majority of prisons.
I would think this was worse than D&D. Not only are you practicing the dark arts of
frozen beef.
Prison food, I don't know what that does to your stats, but you're going to have a bunch of hungry inmates who can't get Wendy's while they're playing this game. I think you're just asking for trouble.
Though I did notice, there is no negative for eating prison food while playing.
I'm guessing that the author didn't contemplate that.
Yeah, exactly. But it's one of those things, I wanted to call it out just because I think it's an incredibly sort of fun thing. It's silly as to what it is. But what really astounded me when I found out about this, I thought it was kind of neat that they'd done this. And so I just went and checked it out. And when I suddenly realized it's a 97-page, full-color,
when you sent it to me, I thought it was like a web game of some kind. Yeah. And I was like, I'll check that out later, because those are a dime a dozen, right? And then we talked this morning, no, it's like a 97-page. Kirk has a color manual printed out.
I have the color manual printed out here from the PDF. You can download the PDF for free.
You got to see it. The art is straight serious. It's like somebody was making... the RPG inversion of a dark comedy. I don't know how to describe it. Yeah. It's worth your time to go look at.
Yeah, although admittedly, and in conjunction with it, one of the magic user characters in this, her staff is glowing with what vaguely looks like the Wendy's logo. So the art, but it is full color. It's done in, it's got full out generated artwork. There's maps in here. There's a substantial number of maps. There's kind of fantasy artwork. Now, admittedly, the fantasy artwork is sort of clearly from, you could say, one person in the way that it's been generated. Yeah. And it only uses a certain limited number of characters in a variety of different poses.
How long until the first Fresh Con where people get together for
to play this game? I kind of want to go to a convention and suggest playing this game. That might be kind of amusing.
We should go to Archon. When's Archon? Is that coming up? Probably
I don't know, but...
Yeah, Archon's our local gaming convention over in Illinois.
Yeah,
that's silly. Too. And I told Kirk earlier, I would like to know how this came to be. I can't imagine that the marketing department at Wendy's sat down and said, here's what we're going to do. We're going to come up with this elaborate RPG that we made from scratch. It's all Wendy's
pen and
themed.
Paper game.
And a pencil and paper game. I could see because nobody's going to play this, right? You and me might someday because we're crazy. But
I'm sure some people are going to play it as a joke.
Yeah, people play it as a joke. But, whereas an online game, people will come back and play if the mechanics are fun. This requires a lot more work. They got to get the dice and learn the rules. So
you don't actually need the dice. You can go to their webpage and they actually have an automatic dice roller for you.
Oh, well, how do we know it's fair? I'm curious how this came to be. I've got to think it was like a running joke inside the Wendy's marketing group somewhere that eventually got out of control, and they were like, all right, at this point, let's just make it into a real thing.
Yeah. It's probably something along those lines. But again, it's one of those things that for this podcast, I think is sort of an amusing anecdote. It kind of fits with today's episode, and particularly having that we just did 2 episodes on Dungeons & Dragons, I thought we needed to bring it up.
Yeah, for sure. Okay, so that's our hour. There's the music, and it's time to go. We're actually not sure on our next topic, so it'll be a surprise to everybody, including us. So also not sure on timing. As we said before, we have busy months coming up, so we may not get to another recording. I'm going to guess we're not going to record until we get back from AIPLA, so probably December sometime will be our next episode. So,
you mean November sometime?
Or what did I say? December? Yeah, November. So don't get excited until then. So at any rate, check out our website at www.lggpodcast.com. The website has links to all of our various platforms where you can download prior episodes. Get in touch with us on Twitter, Facebook, and by email. Please subscribe to our podcast on the platforms. Give us a review to help new listeners find us. If you'd like to talk to me, I am on Twitter at Benjamin Siders, and Kirk is at KirkDMN. That's all for today. We'll see you next time. Lorem, order some Wendy's.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded at Cool Fire Studios in St. Louis, Missouri.